हॅलो गाईस, वेलकम टू इझी लिगल लॉ. आपण पाहत आहोत रिअल इस्टेट लॉज. The Real Estate Act 2016 established a dedicated three-tier quasi-judicial structure to ensure that disputes in real estate sector are resolved with expertise and speed, moving away from the delays of the traditional civil court. तर रेराचे जे डिस्प्यूट असतात ते एक सेपरेट अथॉरिटी, रेरा अथॉरिटी आहे, त्यांच्यासमोर ते हँडल केले जातात आणि एक स्पीडी ट्रायल असतात. The Real Estate Regulatory Authority. This is the first point of contact for regulation and grievance redressal. Every state is mandated to have its own authority. Composition: a chairperson and at least two whole-time members appointed by the state government. Core powers: sumoto power. The authority can initiate an investigation into a project on its own even if no buyer has filed a formal complaint. Interim orders: it can issue stay orders to stop a developer from further construction or marketing while a dispute is being heard. Discovery and inspection: it has power to summon individuals, call for documents, and inspect project accounts. The adjudicating officer: for cases specifically involving compensation under section 12, 14, 18, and 19, the authority appoints a judicial officer, usually a retired district judge, to decide the exact quantum of money to be paid to the buyer. The Real Estate Appellate Tribunal: if a promoter, buyer, or agent is unhappy with the decision of authority or adjudicating officer, they can challenge it here. Establishment: each state must have at least one tribunal. Composition: led by a chairperson who is or has been a judge of high court and includes one judicial member and one technical administrative member. The pre-deposit rule: this is a crucial deterrent against frivolous appeals by builders. For a promoter to file an appeal, they must first deposit at least 30% of the penalty or the entire amount, including interest or compensation ordered by the authority with the tribunal. Time bound: the tribunal is required to dispose of appeal within 60 days. Remedies and enforcement: the Act provides specific teeth to ensure that orders aren't just paper victories. Statutory remedies for buyers: refund with interest. If a project is delayed, the buyer has the right to exit and get every penny back with interest, usually SBI plus 2%. The interest rate or SBI along with 2%. Compensation for defects: if structural defects appear within 5 years, the builder must fix them. If they fail to, the buyer can claim compensation through the adjudicating officers. Specific performance: the authority can force a builder to complete the project or provide the promised amenities. Enforcement of orders: civil court powers. Order passed by the authority or the tribunal are executed as a decree of the civil court. Recovery of arrears: if a builder fails to pay the order compensation or interest, it can be recovered as arrears of land revenue, meaning the government can attach and sell builder's asset to pay the buyer. Final recourse: the High Court. While RERA bars civil courts from entertaining real estate suits, any person aggrieved by an order of the appellate tribunal can file an appeal in the High Court of that state within 60 days, but only on a substantive question of law. The Real Estate Regulatory Authority (RERA) was established to move the real sector from an unregulated landscape to one defined by transparency and legal accountability. Section 20 to 30 of the Rera Act 2016 deals its foundational structure. Establishment: section 20. The acts mandate the creation of state-specific authorities to oversee local real estate markets. Timeline: the appropriate government was required to establish the authority within 1 year of the act coming into force. Multiple authorities or government can establish more than one authority for a single state if the volume of the real estate projects is high. Interim authority: until a permanent authority is established, the government can designate any existing officer as the interim regulatory authority. Section 20. Incorporation: the authority is not just a government department, it is a body corporate. This gives it a specific legal status. Perpetual succession: The authority continues to exist regardless of changes in its members or the government. Common seal, it has an official seal for formal documents. Legal personhood, it has power to acquire and hold property, both movable and immovable, enter into contracts in its own name, sue and be sued on its own name. Composition, Section 21. The authority is designed as a multi-member body to ensure balanced decision making. The chairperson, the head of the authority, members, at least two whole-time members. Qualification for appointment, Section 22. The chairperson and members must be person of ability, integrity and standing with adequate knowledge and at least 20 years of experience for chairperson or 15 years in urban development, housing or real estate, law, commerce or economics, planning, management or social service, public affairs or administration. The selection process, they are appointed by the appropriate government based on the recommendation of selection committee consisting of Chief Justice of High Court, Secretary of Department dealing with housing, the law secretary. Term of office, Section 23, to ensure independence from political or developer pressure. Duration, the chairperson and members hold office of term of 5 years or until they reach age of 65 years, whichever is earlier. No reappointment, they are not eligible for reappointment to the same position to prevent conflicts of interest. To ensure the real estate regulatory authority operates as a professional and independent body, the Act specifies stringent qualifications for its leadership and provides it with expansive powers to regulate the industry. Qualification of chairperson and members, Section 22. The leadership of Rera must consist of experts who understand the complexities of law, urban planning and economics. Chairperson must have at least 20 years of professional experience in fields such as urban development, housing, real estate, law, commerce or administration. Members must have at least 15 years of experience in the same fields. Integrity recruitment, they must be persons of ability, integrity and standing. Conflict of interest, any person who has a financial or other interest in the real estate industry that could affect their function as a member is disqualified from appointment. Meetings of authority, Section 25. The authority functions as a collective body and its decisions are made through a structured meeting process. Frequency, the authority meets at times and places determined by the chairperson. Quorum, decisions are made by a majority of members present and voting. In the event of a tie, the chairperson has a second or casting vote. Validity of actions, no act or proceeding of the authority is invalid merely because of vacancy in the board or a defect in the appointment of a member. Section 35 to 38, powers of authority. The authority is vested with powers of civil court under the Code of Civil Procedure 1908. Discovery and production. Power to summon and enforce attendance of any person, require the discovery and production of documents. Suo motu power. The authority can initiate an investigation into any project on its own motion, even without a formal complaint from a buyer. Search and seizure. It can call for information from any promoter, allottee or agent and direct its officer to inspect books and records. Issue interim orders. It can restrain the promoter or an agent from continuing any act that violates the Rera Act while an inquiry is ongoing. Impose penalties. Power to levy heavy fines and interest for non-compliance with the Act's provision. Section 32 and 34, functions of the authority. The functions of Rera extend beyond just solving dispute. They include the holistic growth of the sector. Administrative functions, registering and regulating real estate projects and real estate agents. Database management, maintaining website for public viewing of all registered projects, including sanction plans and quarterly updates. Standardization, ensuring compliance with the carpet area definition and other standardized norms. Advisory functions, policy advice, to advise the government on the growth and promotion of transparent, efficient and competitive real estate sector. Housing for all, recommending measures to facilitate the construction of environmentally sustainable and affordable housing. Regulatory functions, grievances redressal, deciding on complaints filed by allottees, promoters, or agents. Compliance monitoring, ensuring promoters deposit 70% of collection in escrow account and complete project within the declared timeline. Under the Rera Act, the grievance redressal mechanism is designed to be accessible, time-bound, and legally robust. It ensures that any aggrieved person, whether a buyer, builder, or agent, has clear path to justice. Section 31, filing of complaints. Any person can file a complaint with the regulatory authority or adjudicating officer for any violation of the Act. Who can file? Allottees, individual or association, promoters, or real estate agents. Grounds for complaint. Common grounds include delay in possession, structural defects, non-disclosure of information, or demand for more than 10% advance without a registered agreement. The process, online filing. Most states require complaints to be filed through their official portal. Form and fees typically filled under Form A or Form B. Fees vary by state, usually between 1,000 to 5,000. Time frame. The authority is mandated to dispose the complaint within 60 days. If it takes longer, they must record the reason for the delay. Powers of authority, section 35 to 38. The authority acts as quasi-judicial body with the same power as civil court. Suo motu power, Rera can start an investigation on its own if no one has complained. Investigative powers, it can summon witness, examine them on oath, and require the discovery and production of books of accounts, section 35. Interim orders, if an ongoing act is likely to cause irreparable harm, the authority can issue an order to stop that act until the case is decided, section 36. Referral to Competition Commission, if the authority finds signs or monopoly or anti-competitive behavior by a large developer, it can refer the case to CCI, section 33. Enforcement of orders, section 40. An order is only as good as its execution. Rera provides two primary methods to enforce its decision. Recovery as arrears of land revenue. If a promoter or agent fails to pay a penalty or compensation, the authority can recover the amount as if it were unpaid land tax. This allows the government to attach and sell the developer assets to pay the complainant. Civil court status. Every order passed by the authority or appellate tribunal is enforceable as a decree of civil court. If the party still doesn't comply, they can face civil imprisonment. Appearance and legal representation, section 56. Rera is defined to be user-friendly, meaning you don't always need a lawyer to fight your case. Right to appear in person. You, the applicant or appellant, can present your own case before authority or the tribunal. Professional representation. You can authorize any of the following professional to represent you: legal practitioners, advocates or lawyers, chartered accountants, company secretaries, cost accountants. The benefit: this flexibility allows for technical dispute like financial audit or project to be handled by CS, while legal dispute are handled by lawyers. Section 88 and 89 of the Real Estate Act 2016 established the legal weight of Rera in relation to other Indian laws. Together, they create a dual layer protection for buyers while ensuring Rera remains the final word in case of a conflict. Section 88, application of other laws not barred. This section establishes that Rera is not meant to replace existing laws but to work alongside with them. In addition to, the Act explicitly states that its provisions are in addition to and not in derogation of any other laws currently in force. Effect: a buyer can seek remedies under Rera while simultaneously using other laws such as the Consumer Protection Act to seek compensation for deficiency in service, the IBC Insolvency and Bankruptcy Code if the developer goes bankrupt, state-specific act like the MOFA Maharashtra Ownership of Flat Act or local municipal laws. Practical benefit: if a particular relief is covered by Rera but exists in another law, the buyer is still entitled to it. Section 89 act to have overriding effect, while Section 88 says RERA works with other laws. Section 89 clarifies that what happens when there is a direct clash. Notwithstanding clause, this section states that provision of RERA shall have effect even if they are inconsistent with any other law for the time being in force. The tiebreaker in any situation where a local or older law says one thing and RERA says another, RERA wins. Example, if an older state law says builder can change a building plan with only 50% consent, but RERA says two-third consent is required, the RERA rule two-third must be followed. This ensures a uniform standard of protection across India, preventing state level loopholes from weakening consumer rights. Section 79 of Rera Act 2016 is a critical provision that establishes the bar of jurisdiction. Its primary purpose is to ensure that real estate disputes are handled by specialized RERA authorities rather than becoming bogged down in the slow moving machinery of traditional civil courts. The core provision, Section 79, states two primary restrictions. No civil court jurisdiction. No civil court has the power to entertain any suit or proceeding regarding any matter that the RERA authority, the adjudicating officer, or the appellate tribunal is empowered to decide. No injunctions, no court or other authority can grant an injunction against any action taken or to be taken by the RERA authority in pursuance of their power under the Act. Why does this bar exist? Before 2016, builder often used civil court litigation to display project or stall consumer complaints for decades. Section 79 was designed to create a one-stop shop, channel all technical real estate issues, carpet area, projection, registration, escrow account to experts, prevent parallel proceedings, stop parties from filing the same case in multiple civil court to confuse the legal outcome, speed up resolution. RERA is mandated to resolve the case within 60 days, a timeline civil courts rarely meet. The not absolute nature of the bar, while Section 79 sounds like a total ban, Indian courts, including Supreme Court, have clarified several important exceptions. The Consumer Forum exception, the Supreme Court in Imperial Structure Limited versus Anil Patni ruled that Section 79 bars civil court but does not bar consumer commissions. Reason, the consumer forums are quasi-judicial bodies, not civil courts under the Code of Civil Procedure. Effect, a home buyer has the choice or discretion to approach either RERA or the consumer forum. Matters outside RERA scope, if a dispute does not fall under the scope, power and function of RERA, a civil suit remains maintainable. Example, a pure contractual dispute between two private parties that does not involve a promoter or a registered project might still go to a civil court. Example, dispute regarding the inheritance or title of a property, who is the legal heir, are typically still handled by civil courts as RERA focuses on transactional and regulatory aspect of development. Arbitration, Section 79 specifically names civil courts. Therefore, if a builder-buyer agreement has an arbitration clause, parties can still opt for arbitration. However, the RERA remedy is considered an additional remedy that buyer can choose even if an arbitration agreement exists.